You will not be disappointed in this panel. We have a wonderful guest to my left, your right, Ms. Lise Vihul. She is the CEO of CyberLaw International, ambassador of the NATO Cooperative Cyber Defense Center of Excellence, CCDCOE, that you've been hearing about so much this week, where she spent many years in the law and policy branch. She's a managing editor of the Talon Manual 2.0 on the international law applicable to cyber operations, with which many of you are familiar. She worked with the Estonian Ministry of Foreign Affairs in the UNGGE in this area, and of course is just a wealth of knowledge in international law and the intersection with cyber. So Lise, welcome. To her left and your right, we have a man who really needs no introduction, Professor Mike Schmidt. Mike is a professor of public international law at the University of Exeter in the UK. He is a Howard S. Levy Chair at the Naval War College in Newport. He is a Francis Lieber Distinguished Scholar at the U.S. Military Academy at West Point, up with us at near the ACI. 20-year career as an Air Force officer. Former Dean of the Marshall Center in Germany. Senior Fellow at NATO CCDCOE. Awarded the Cross of Terra Mariana by the President of Estonia for his great contribution to that nation. And last but certainly not least, General Editor of the Talon Manual. Thank you for being here, Mike.
My pleasure.
And a third giant in the cyber war arena, though not a lawyer, which is great for us to have on this panel, Dr. Martin Libicki. He is a Kaiser Chair of Cybersecurity Studies at the U.S. Naval Academy in Annapolis, has written several books, including textbooks on cyber war. His government service includes many years at the NDU, National Defense University, GAO, and on the Navy staff and the RAND Corporation. So, we are proud to say we have representation from the Army, Air Force, Navy, and NATO here. As it relates to Dr. Libicki, we must share, it's sort of my duty to share with you that the Army team defeated the Navy team last 2 years on the gridiron. As many in this room know, after about 15 years in a row of losing, Army beat Navy. The West Point cadets stormed the field in victory. Perhaps you saw this on TV. And after the game, a lot of our generals got calls saying it was the most orderly storming of the field they had ever seen. So we're very proud of our cadets. Most importantly, we welcome Dr. Libicki and the entire panel to what will be a great session here. Quick admin note, Dr. Libicki will have to leave around 11. We will shift from our discussion on cyber sovereignty writ large to an opportunity to talk to Professor Schmidt and Ms. Vihul about any topic you like in public international law. So think about those questions. It's a rare opportunity to have them here. And unfortunately, Dr. Libicki has some other events to go to, and then he has to teach. So we will have, but we will have this good opportunity during the question and answer period. And we'll open it up before then, so you can also ask Dr. Libicki questions. But if you see him leaving, that is why. All right, back to our theme, as we've been discussing all week, on competition and conflict. For those who've not heard or may have just come today, this is the idea that regardless of whether we're talking about acquisition or technical expertise or law, everything matters in the competition phase when states are competing with one another. Essentially, there is no peace. There are two phases of conflict: competition into actual armed conflict, back into competition. So that's the idea, that's the theme of this conference, and we'll see how that relates to the law, particularly in the area of sovereignty. Does it fit neatly? Certainly, sovereignty is a national interest, and our positions on that matter as far as our own and our allies during this time of competition could have an effect on where we are perceived during times of conflict. So we'll talk about that. And does that fit neatly into our jus ad bellum, jus in bello construct or not? So, game plan for the panel is to just go ahead and ask some basic questions, some introductory questions of each panel member, get you thinking, because the most fun is obviously to have your questions for our panel. So we'll open it up to your questions. But we'll start by asking Ms. Vihul, what is all this fuss about sovereignty? What are we really talking about in general terms?
Before I answer the question, I just wanted to say good morning to all of you, and of course a big thank you to Army Cyber Institute and the CCD COE, my former home, for having me here today. But when we talk about sovereignty, I think the first thing that we need to be cognizant of is the fact that when people use this term, they do not necessarily interpret and understand it in the exact same manner. In other words, sovereignty, because it lacks a definition, tends to mean slightly different things to different people and to professionals coming from different fields. When politicians use this term, which they often do, and sometimes also when journalists refer to sovereignty, it seems to me that what they generally have in mind is the right of a state to be left alone, to conduct its affairs without outside interference. In international law, this notion is actually more akin to the prohibition of intervention, which is a different legal rule than that of sovereignty. And this, I'm sure, will be discussed in more detail in this panel. Now, when lawyers talk about sovereignty, they usually call it the principle of sovereignty or the rule of sovereignty, then it carries a slightly different meaning, and it's generally more focused on territoriality, the territorial nature of a nation state, and territorial integrity and inviolability. That's the starting point generally for lawyers when we talk about sovereignty. And we can actually see this difference in the meaning of the term play out in diplomacy. When we look at the 2015 UN GGE report, which I'm sure many of you have read, then you'll notice that sovereignty features there quite prominently. It appears, I believe, 5 times. We also know that the GGE reports are adopted by consensus, which means that countries falling to either side of the aisle, if you will, endorsed that report. So how come countries like Russia and China, which understand sovereignty quite differently from Western liberal democracies, all agreed that sovereignty should end up in the report? And I think the answer here lies in this very same fact that sovereignty by different professionals, as well as by different countries, is understood in a slightly different manner. It's a very important caveat that we have to keep in mind also when we discuss what sovereignty means in the cyber context. We may not necessarily even be defining the term in the same manner. I think I'll leave it at that.
Okay, well, we'll turn to Professor Schmidt and ask what is the standard, just so our audience is clear, standard of sovereignty in international law, and if you may tell us what the Talon International Group of Experts had to say about this.
Well, I don't know that we know what sovereignty is in international law because a debate has emerged, and I'll turn to that in just a moment. But I can tell you what the Talon Manual folks believe sovereignty was. Sovereignty is a rule of international law, and it has 2 components. The first is the one Lise mentioned, territoriality. And what we said is that if certain effects occur on the territory of a state, those effects implicate the sovereignty of that state and may indeed violate the sovereignty of the state. So as Lise said, sovereignty is about territoriality, and just like a jet passing into national airspace, when you have a cyber operation conducted remotely from outside the boundaries of a state into a state, sometimes those effects can be characterized as a violation of sovereignty. Now, the problem is we could not quite come to a consensus on when that was the case, when you violated territorial sovereignty. It was clearly the case for all of the experts involved in the process that when there was any kind of damage, when there was a physical effect in the territory of the state into which you were operating, that would constitute a violation of sovereignty. On the other hand, we came to the conclusion that conducting espionage into cyber infrastructure on the territory of a state was not a violation of sovereignty, and the basis for that conclusion had to be was the extensive state practice that we've seen over time. So our problem, and I believe the problem that states should be struggling with now, is what about all the stuff in between? What about if you're manipulating data, cyber operations that cause serious adverse effects with regard to the rights of other states? In other words, you have to police your territory. So sovereignty, the right, comes with an obligation of due diligence. And now this leads me to where I'll close. And when I started, I said I thought we knew what sovereignty was, but now we're not so sure. And that's because a debate has emerged. And the debate goes like this. There is the Tallinn Manual view, and I would say the view of most scholars that we've talked to and the view of many states, that sovereignty is a rule of international law. What do I mean? I mean you violate rules. So a cyber operation by state A that causes destructive consequences in state B is a violation of international law, what we lawyers would call an internationally wrongful act. We thought in the Tallinn Manual group, we thought this was pretty clear. However, a couple of years ago, and notably last year at this conference, a different view has emerged. And it is the view that sovereignty is not a rule of international law that you violate, but rather a principle. What is a principle in international law? A principle is a premise, a concept from which rules emerge. So sovereignty is the general notion that states should be able to control what's going on in their territory and so forth. You don't violate sovereignty, but rather you look for rules that come from sovereignty. And the three big ones are the principle of non-intervention, which Lise has just mentioned. You can't coercively interfere in matters reserved to the state. The prohibition on the use of force found in the UN Charter and customary international law. And the rule of justification, the rules regarding jurisdiction. Finally, I would note that until recently, no state had expressly adopted that position. I know that here in this country, there are interagency debates about this, about whether the United States wants to adopt the notion that there's no rule of sovereignty, or whether it wants to say, no, there is a rule of sovereignty and cyber operations can violate it. The United Kingdom recently, this summer, the Attorney General of the United Kingdom, in a very, very, very important speech at Chatham House, the Attorney General set forth perhaps the most robust, granular statement of a state's view of international law in cyberspace. But one of the things he said was that the United Kingdom rejects the notion of sovereignty has a rule that may be violated. Now, why would this be? This is because if you want to conduct operations into other states, you probably don't like a rule of sovereignty because it may in some cases prohibit those operations. But of course, law applies equally to all states. And so what this means, and we'll talk about this later, I believe, what this means is you also cannot look to that rule to condemn the activities of other states when they come into your territory by cyber means.
Thanks, Mike, for the excellent framework and giving us a background, I think a fair representation of the debate that's currently ongoing. I turn to Martin. Dr. Libicki, what do you think of all this from a non-lawyer's perspective? What do you make of all this?
I didn't even play one on television. Let me start off by pivoting off something Professor Schmidt said. Okay, and he asked the question, is cyberspace sort of a domain over which you can state sovereignty claims, right? Is there such a thing as sovereignty in cyberspace? And if I hear incorrectly, the answer is under current law, you can't. Okay, current law doesn't recognize that. But as a policy and economist guy, I'm going to ask a slightly different question. Should there be a notion of sovereignty over cyberspace? And I'm going to give a rather limited answer in the sense that it is not in the U.S. interest, and by the extension, the interest of the West, to define something called sovereignty over cyberspace. And I'm going to make 3 points. The first point I'm going to make is it is not the nature of the medium for which sovereignty is a particularly good fit as a concept, okay? Now, some people will say, of course you can define sovereignty in cyberspace because all the elements of cyberspace, the routers, the wires, the links, have to exist somewhere. And the territoriality of where they exist, therefore, defines the basis for sovereignty in cyberspace. And I have to admit that everything in this world exists somewhere. Fair enough, okay? But from a practical perspective, first of all, the physical layer of cyberspace is only one of multiple layers of cyberspace, and is often the one that the user is least aware of. Okay? For instance, Could you as a user tell whether your router is sitting on somebody's territory, whose territory it might sit on, or whether in fact it sits on a satellite or some airborne vehicle that may be offshore? To the user, as long as you have roughly comparable levels of service, it doesn't matter. And yet for the purposes of jurisdiction, the argument would be that it should matter. Okay? Now let me take a look at it from the other end. One of the characteristics of sovereignty is the ability to know that something is happening in your territory. Well, can a country know that of what kind of data and communications are taking place in its territory? And the answer is, it's getting harder every year. And it's getting harder every year as an increasing percentage of all the data at flow and the data at rest is becoming encrypted, and the governments don't necessarily have the keys to it. Okay? So when you talk about sovereignty in cyberspace, you're talking about a sovereignty that exists despite the fact that the users are unaware of it, and despite the fact that the government is unaware of the content of what it is that they're supposed to be sovereign over. Okay? And that's a major conceptual problem. The second point I would like to make is, at least from the U.S. and by extension the Western perspective, we do not need a definition of sovereignty in order to carry out the sorts of regulations or law enforcement activities or international activities that we want. For instance, has somebody committed a crime in cyberspace? Well, the usual tests of this, whether it's in your jurisdiction, is, do you have a victim, right? Is the victim of the crime in cyberspace somebody that you are responsible to? Okay? So the victim is going to be, of course, a person. In many cases, it could be a corporate person, but in any case, it's something that has something that has a physical existence. Well, what about the perpetrator? Cyberspace is one of these unique domains in which the perpetrator and the victim don't necessarily have to share the same space. And the answer then becomes, it's a matter of extradition. Or more broadly, can you get your hands on the perpetrator? And sometimes you can, and sometimes you can't. And we have a long history of extradition, what can and cannot be extradited. Okay? If you want to talk about regulations, the regulations that we have in this country apply, for instance, to the telecommunications infrastructure, which is a physical infrastructure and gives us a basis for regulation. Almost everything we want to do does not need a notion of sovereignty in cyberspace, because the other sovereignties that we have in physical space are more or less sufficient for that. But that gets me to point number 3. And point number 3 is that there are practices that currently define their legitimacy, their rationale, in terms of sovereignty in cyberspace. And specifically, I'm talking about censorship. Okay? What is the rationale for a country such as China to be able to exercise censorship over its people? Well, they don't really like to call it that, okay? That just has a bad taste in their mouth. So what it's often said in China is that China is exercising its sovereignty over cyberspace, okay? And then you don't have to get into the question about what is it that China is actually exercising its sovereignty over. If we, the United States, or the West in general, says, yes, there is such a thing in sovereignty in cyberspace, then we have to admit to countries that would censor their internet that, in fact, you have a legitimate basis for doing it. If, on the other hand, we say sovereignty is not a concept that applies in this construct of cyberspace, then we force people either to contest this notion or, more broadly, to base a notion on something else. And that something else is going to be a country's ability to control what people in their citizens actually know. What is the information that comes to these citizens? Which actually gets to a philosophical conundrum, and since it is a conundrum, and it is philosophical, I'll be pretty brief. But the answer is, who owns truth, right? Does truth arise from objective circumstances, or is truth something that can be owned by governments? In the United States, we believe, I hope we believe, I'm not making a politically contentious statement, that in fact truth is founded on objective reality, and that the means for truth involve free communications. But if you're in a milieu in which truth in fact is something that is under the sovereign control of the government, and is not an objective matter, then something such as sovereignty in cyberspace helps that philosophy.
Thank you, Dr. Levicki. And a quick response from Mike to what Martin
Well, I mean, I think I agree with everything Professor Levicki said, but I did want to highlight, I was having a discussion with one of my friends before the session. There is a sense that the West and the rest, China and Russia, see sovereignty differently, and I'm not convinced that's the case. I happen to believe that China and Russia has a sovereign prerogative, have the right to control what their people do in cyberspace. That's classic sovereignty. And I don't think we need to debate, I don't think we need to object to that, to nevertheless say, but you cannot control them in certain manners. And the reason is a different body of law intrudes. We can have exactly the same concept of sovereignty, but we must remember that the principle of sovereignty is without prejudice the application of other rules of international law. And the law that keeps the Chinese from doing that isn't a sovereignty debate. The law that keeps the Chinese from doing that is international human rights law. So this debate about the Chinese and control over and censorship and control over the internet should be a debate we should be having in a different area of the law, not sovereignty, but rather what's the scope of a state's international human rights obligations, particularly expression and privacy.
Right. Please, your response.
Oh, I also agree with, I think, everything that you said.
Absolutely.
I agree that cyberspace challenges the traditional understanding of sovereignty. You gave a great example, which is uncertainty about where your potential target resides, in which country. So if you're a state that wants to undertake a counter-terrorist cyber operation, you identify cyber infrastructure that a particular terrorist group is using, but you don't know where that cyber infrastructure is located, then you don't actually know which country's sovereignty you should be considering as you plan to engage that cyber infrastructure. It's a very good example of how cyberspace and the notion of sovereignty do not match entirely well. And I've seen this play out in diplomacy that from an international policy perspective, yeah, sovereignty is problematic for Western liberal democracies for the very reasons that you mentioned. I mean, sovereignty in that rhetoric supports arguments for data localization, for limitations on human rights, for censorship, for restriction on speech. It undermines net neutrality, the free flow of information. So there's a plethora of arguments in the policy realm that speak against using sovereignty in that narrative. And it's also evident in the United States proposal to establishing the new group of governmental experts that was adopted in the First Committee of the General Assembly a couple of weeks ago. When you look at the U.S. proposal, it doesn't make a single reference to sovereignty. Whereas the Russian proposal that established the open-ending working group, again, makes 5 references to sovereignty. So on the policy plane, yes, I agree that sovereignty is problematic. But I think there is a very strong counter-argument to not to dismiss sovereignty in its entirety, and that takes us back to the international law domain. And the reason I say this is because, in my view, sovereignty is probably the most important international law rule that we have. Why? Because it is the rule that protects states against other states, from other states' malicious cyber activity. There are other rules, like Professor Schmidt also mentioned, the prohibition of intervention, the prohibition of the use of force, but those are both quite high thresholds. Most malicious cyber activity by states falls below those 2 thresholds. And it is at this point where sovereignty places a slightly lower threshold for malicious cyber activity by one state against another state. And therefore, viewed from an international peace and security perspective, the international law notion of sovereignty, I think, carries a lot of strategic and operational weight.
And you mentioned the diplomacy piece. I know you've written about this before, but talk about, if you would, very briefly, when states make public positions or statements about their positions, how does that help us? Mike alluded to the UK Attorney General's speech and that sort of thing. As we relate back to the law, how does that help us, in your opinion? or does it not help us?
Well, I think it provides us a degree of foreseeability as to how states will actually carry out their cyber operations, cyber activities, which activities they believe they are entitled to engage in, and which activities they consider to be prohibited by the law. But this particular sovereignty debate actually is very fascinating as well, because it's a debate that is very law nerdy and probably not too interesting for non-lawyers, but it has given us a little glimpse into the classified operational reality that we don't hear too much about. Because when the Brits come out and they officially say that they reject the rule of sovereignty as something that exists in international law, at least it made me ask, well, why did they do this? Why are they saying that there is no such thing as a rule of sovereignty that places a limit on their cyber operations? Well, and the answer must be that they actually want to engage in those cyber operations that would be at the violation of sovereignty threshold. So for them, the space to engage in offensive cyber activity now is much bigger. It is only at the prohibition of intervention and use of force threshold, those high threshold prohibitions, where the red line becomes applicable to them. So it was a very interesting debate. We don't really hear much about what states do in cyberspace, but through this legal position, we at least got a little sense of it.
Right, and can be state practice leading to potential customary international law. Mike?
So, I mean, I think this UK situation is absolutely fascinating, because folks like Lisa and I have been traveling around the world and talking to states, and our message, our mantra is states need to publicly state what their legal position is, because unless states do, you can't have either a agreed upon interpretation of an existing norm, or you can't see new norms emerge to meet the demands of cyber operations. So in May, Jeremy Wright, the Attorney General, goes to Chatham House, as I mentioned, and he sets forth not just sovereignty. Sovereignty was only a tiny piece of the speech. It was a long speech in which he set forth a lot of rules. And so people like us are thrilled to death. There we go. The UK has said there's a use of force rule in cyberspace. They gave us examples. They gave us examples of intervention. This is exactly what we've been asking for. But in life, I mean, you need to be careful what you ask for, because we're reading along and we're going, yeah, these guys finally got it. And then boom, when you ask someone to set forth their views, the risk is that they may set forth a view with which you do not agree. And so they set forth the view on sovereignty. Well, I mean, you know, if you're going to ask states to do that, you have to live with the consequences. States make law, not international law professors or CEOs of law firms. However, then fast forward to October. In October, the GCHQ releases there was a news release in October in which it condemned Russian activities. And it went through a long litany of Russian activities, which it labeled as unlawful. Well, that's great. I mean, I've got to tell you, I think the Russians are generally an unlawful group. However, they had taken sovereignty off the table the previous May. So now the question is, for the attorney, I'm seeing that you're calling the Russians unlawful, and by the way, I happen to agree with you. But what's your legal basis for coming to that conclusion now that you've dispensed with sovereignty? Because in those incidents, it is arguable that some of them are violations of the prohibition of intervention. It's arguable that a couple of them that were destructive were violations of the prohibition on the use of force. But in the vast majority of the examples cited in the GCHQ news release, the only colorable, the only reasonable, the only viable argument that it was unlawful was that it was a violation of sovereignty. And therein lies the problem. By virtue of the principle of sovereign equality, if you take a position, you have to understand it applies to you. So although you may wish, as Lee's correctly identified, although you may wish to avoid international law serving as an impediment to your cyber operations, you must understand that it releases the other side to conduct those operations against you. This was a very interesting case because it deprived the Brits of being able to make a convincing naming and shaming argument with regard to the Russians. And I believe that's highly problematic for people that are going to dig into what they had to say.
Something you've written about in the European Journal of International Law, amongst other scholarship in the last few weeks. I think it's a great piece and a great recap of the UK Attorney General's speech if you haven't seen it. Martin, if I may return to you for a related topic, and then we'll open it up to some questions. Plenty of topics to talk about, but I think we have some really good ones on the floor here. Just the DoD cyber strategy, talking about defending forward, right? So this has been talked about a little bit this week. Does that change your view or your opinion of sovereignty as you laid it out, or does it fit in nicely with your construct of sovereignty?
Well, it's sort of orthogonal to my construct of sovereignty because it doesn't really assert rights, but it sort of basically says, look, we are in an era of conflict, and if there are cost-effective ways for us to mitigate the effects on the United States by going into red space or gray space, we'll do that. Now, having said as much, my hunch, and I don't know this for certain, but my hunch is that we didn't start going into red space when we issued a document that said we were going to red space. We've been going into the red space for a good long time. And the test of that, in many ways, is one of efficacy. That is to say, given the effort that you're making, are you doing yourself any good? Are you establishing precedent for other folks to follow? And the answer is yes, but I think in the United States, we tend to exaggerate the extent to which we set the precedent for others. A lot of people aren't waiting around for us to do things, for them to go off and do things to us. And you also have to worry about the sort of stability issues. In other words, what are people going to infer from what you do? Although it happens to be my opinion that we've greatly exaggerated that. I'll tell you a quick story. About 11 years ago, I was looking at pronouncements by Iraqi insurgents on what kind of attacks they had carried out against Americans. It turns out that I was getting my information from the Open Source Center of the CIA, and therefore I had to work in classified spaces, even though the information I was working with was produced by our adversaries for the public. Why did I have to do that? Well, because otherwise it would be a violation of copyright. But as I was sitting there in my classified spaces working on this, I said, I rather doubt that the United States can be successfully sued by an Iraqi insurgent group for violating their copyright. So this is by way of saying that I rather doubt that the folks that we're going after in cyberspace have a leg to stand on because we're interfering with their offensive operations.
Excellent. All right, we'll turn to the audience here for some questions before Dr. Libicki has to leave. I see one up front, if we could, Victor. Please. It's hard for us to see up here, so if you speak in the microphone and tell us who you are, if you would be so kind.
Sure. Milton Mueller, Georgia Tech. Yeah, I've been trying to address this issue of sovereignty in cyberspace. I've been arguing that it doesn't exist and shouldn't exist. I think Professor Libicki kind of hit the nail on the head, and I want to emphasize a point and see how Professor Schmidt and, I'm sorry,
Ms.
Miel, how they would react to this. So he talked about the sovereignty as a rationalization for censorship, and that is certainly true. I think that hits the nail on the head. And I think that actually understates the impact of a sovereignty approach to cyberspace, because what we're doing now is a massive project of territorialization of data. It's about some people are explicitly calling for data sovereignty. Some people are enacting data localization measures. Some people are erecting trade barriers to global platforms. And so you're seeing an incredible process of redividing the internet, which globally connected us, into these territorial spaces. And the rationale is always sovereignty. And the only thing I heard you say against that sort of dismissal of the concept of sovereignty is that if we don't have it, then we might be attacked by these countries that are also violating sovereignty. But to that I would say, isn't it just a crime to be breaking into computer systems and doing things? Why do you need the notion of sovereignty? Because it is in kind of a non-territorial space. And secondly, why doesn't anybody ever talk about other non-sovereign domains such as the oceans and outer space, in which we managed to have conflicts and manage resolution of conflicts without any notion of sovereignty. They're explicitly in the treaties identified as non-sovereign spaces. Thank you.
Thank you. Thoughts from the panel? Martin, actually, you talked about the domains, too, in your writing quite a bit. So we could take the second first and talk about the relationship between criminal law and
let me just make a couple of comments here, other than the fact a lot of data localization stuff is a jobs program. First notion is we have this intuitive notion that a country's critical infrastructure sits in its own country itself, but that's becoming, we're getting to the point where that may not be true anymore. For instance, one of the most important parts of a critical infrastructure is to be able to process bank transactions. There's no law. Okay. There's no physical law that says that those transactions have to take place in your country. And there's, what? They're increasing. Yes. I said there's no physical law. That's why I interjected physical. Okay. But as long as we're going to talk about physics, I want to make another statement. The notion that data actually sits somewhere, right, may not be true if you keep your data in a neural net, in which the data exists in terms of associations between various nodes. And so the notion of that there is data at rest in a particular location, whereas it's mostly true today, is it going to be true 10 and 20 and 30 years from now? Question mark? Okay, have you guys finished writing your notes?
Want to go first?
Go ahead.
Please.
Okay. Again, I agree with sovereignty being problematic from a policy perspective, domestic policy, international policy, but I don't think it's realistic to dispense with it in its entirety. So I think lawyers will need sovereignty to be able to make credible legal arguments as they advise their superiors. Dispensing with sovereignty would just have too far-reaching consequences. If you say sovereignty doesn't exist with regard to cyber activities, jurisdiction will fade away. Why? Because jurisdiction is it's premised on sovereignty. So from a strictly international legal perspective, it would be very, very problematic just to say no sovereignty in cyberspace. What would be the solution? I think especially in diplomacy, perhaps adding a little bit more granularity to the statements concerning sovereignty, especially on the part of the Western liberal democracies. In other words, not just agreeing or saying that sovereignty applies, but, for instance, saying that the international law principle of sovereignty is applicable in cyberspace. Just small tweaks to the language that they use as they engage in diplomacy could be helpful.
So I'll respond. I'm an international lawyer, and I believe that the job of an international lawyer is not to get to yes for the boss, but rather to provide an objective assessment of the law for the boss so that the boss can do a legal risk assessment. In other words, if this is the prevailing view, if you choose to go the other way, you need to understand that this is going to be the blowback. People will name and shame you, except they may take countermeasures against you, and so forth. So when I hear people tell me, I don't believe there is sovereignty, it has happened last year. We had a panel on sovereignty, and Gary Korn, the staff judge advocate of Cyber Command, and a close friend of mine made this argument. My response to people who claim there's no sovereignty is, how do you explain the fact that for years and decades and centuries, we have been speaking of violations of sovereignty? Lise and I, mostly Lise, did a survey of statements in the UN, statements by governments, condemnations of activities that were described as a violation of the rule of sovereignty. It is crystal clear, without a scintilla of doubt, that states believe there is a rule of sovereignty. So for me, when someone says there's no sovereignty, I say, where's the beef? Show me why this is different. And that's why, as Martin said, and as I mentioned, we've limited it to classic sovereignty. And so I come from that school that says, maybe it would be good not to have sovereignty. I have a view on this, but maybe it would be good not to have sovereignty. But as an attorney, I need to make an objective analysis of the situation, and it's clear that there has long been a rule of sovereignty, and no one has yet explained to me why it, as a matter of law, in terms of legal interpretation, not as, oh, cyberspace is different, but in terms of classic legal interpretation, the crystallization of customary law, the interpretation of customary and treaty law norms. No one's been able to explain to date why there isn't sovereignty over infrastructure through which cyber operations are conducted, from which cyber operations are conducted, or individuals who conduct cyber activities on territory. And here, I hearken back to what Martin and Lees have said. It's all about jurisdiction. Guess what? There's no such thing as jurisdiction without sovereignty. You can't look to criminal law. Criminal law is about the international law notion of jurisdiction, which derives from sovereignty. If you get rid of sovereignty, you throw the baby out with the bathwater. Outer space is a place. We're doing a manual on outer space called the Woomer Manual. The oceans, I'm at the Naval War College. It's a place. It's a place. It's a commons. Cyberspace is not a place. Point to cyberspace and I'll concede. Point. It's a virtual space. I don't know what that means in the narrative of international law. I understand your point, but in the context of international law, we think territoriality, in terms of territoriality. And the ocean is a place. It has an exclusive economic zone. It has a territorial sea. Outer space is a place. We struggle over where airspace divides from outer space. We struggle over identifying that point. But we concede the point that outer space is somewhere. Airspace is a national or national is somewhere as well. I accept the fact we only do lex lata here. That's what I'm saying.
Sorry, I have to go to...
What? Okay. Perfect timing. Yeah. Martin, you have to leave, but I want to publicly thank Martin for being here with us. He's a busy man, so thanks for coming.
So thanks, Martin.
Drop the mic on the way out, and Eli will have your chocolates for you. But we're not leaving, and this is a very good representation.
I'm not going anywhere until we settle and agree upon this matter.
That's right.
All right, I just wanted to know.
But he left.
So this question was for Martin, but I'll leave it to the remaining panelists to answer. Forrest here from now from SAIC.
Thank you, Forrest.
And so, getting back, and this draws on the previous discussion we just had. So, but Martin made the comment, if I understood it correctly here, from a practical perspective, the physical layer is the one that user is least aware of. Now, if we're making the assumption that the user, in this case, is going to be a sovereign actor, meaning one who is a government who has the authority to do something, should we not expect them to, from a professional, responsible perspective, to at least the endpoints of what they're doing that might happen in cyberspace, know where those physical nodes are and what the implications are of going through? And if there's another country that they've identified that there's activities taking place there that they're concerned about, allow that other country to exercise due diligence to address the problem that's occurring on their physical nodes that they're aware of. Right. Would that not be should that not be expected, or should we just say, hey, like Martin said, is the user's least aware of that, so why bother with them with the responsibility for knowing where the physical nodes are? Not the content flowing through it, but the physical nodes and which endpoints.
Thank you, Forrest.
Well, I would say that a lack of knowledge on the part of a state engaged in an offensive cyber activity, if you will, does not excuse that state. It's not a get-out-of-jail-free card as such to engage in that particular operation. So it may happen that the state gets lucky. So, for instance, if, again, we take counter-terrorist cyber operations, we talk about ISIS's infrastructure located in Syria, and if the cyber command were to want to take down that cyber infrastructure, but is unsure that that cyber infrastructure actually is in Syria, and then engages in that operation, that will be lawful in all likelihood.
Unlawful or lawful?
Lawful, permissible. But if that infrastructure were in Estonia instead, and Cybercom then carried out that operation, then it would be unlawful. depending on the consequences, of course. So I would say that the answer here is, from the legal perspective, the fact that you as a state engaged in that operation don't know where that infrastructure is does not automatically legitimize your operation.
So it starts snowing today, and we're at the hotel waiting to get on the taxi, and it's awful, and the taxi's not coming. And we had exactly this discussion. I have to tell you, I disagree. First of all, in terms of if you know where it is, Lise is the world's expert on due diligence. She literally wrote the book. She's responsible primarily for the due diligence section of the Tallinn Manual. So if you know where that cyber infrastructure is, you should give that state an opportunity to comply with its obligation of due diligence, to put an end to the hostile cyber operations against you. I'm an advocate, as I am in drone warfare, but also in cyberspace, of the unwilling, unable premise. If a state is unwilling or unable, and so that's the point Lise made, then you can conduct operations. And I also believe that if you know where it is and you believe that letting them know that you know that something bad is happening from their territory will preclude the ability to put an end to that operation. I believe you can act without notifying the state. But then we get to the point where Lise and I disagree, which is kind of uncommon since we did the Tallinn Manual together for 7 years. I believe that if you don't know where it is, then you get into the area, you get into the practice of balancing respective rights of states. And so you have to ask, what's at risk for you? What are the consequences for you? Are we talking self-defense? Because if we're talking self-defense, and it's very important to you, that would justify the violation of sovereignty of another state, even though you don't know where that state is. So the mere fact that you don't know where it is doesn't make it unlawful. So here I disagree with Lise. But what I would say is it doesn't necessarily make it lawful. You have to ask about the competing rights in international law that both states enjoy and ask which prevails in this particular circumstance. I will tell you that this is, of course, the basis for the unwilling, unable doctrine. Because with drone warfare, the premise there is a state, the United States, we have a right of self-defense. The other state has a right of sovereignty, territorial sovereignty. If that state is unwilling, unable, then for a moment, in order to defend ourselves, we may pierce the veil of sovereignty to defend ourselves and do no more than that. So in the case where the state is unknowing, I would apply the same legal analysis, balancing of conflicting international law rights.
So given that there would be cases in which it would be expected to make a determination, I think that you're in disagreement with Martin, because I got the impression from him saying that you shouldn't have to bother. If I understood his point correctly. But he's not here to
All right.
Yeah, I'm kind of in agreement with him, but what I'm saying is you don't say I don't have to bother. What you say is I have to look at the competing consequences to the various states. So it's not as if there's no law, there's law, but you have to do a balancing test. And I believe Lise is saying it's simply unlawful. You can't just shoot into the blind, which is, by the way, a reasonable view. And this is a wonderful example for us where states need to think this through and determine what their legal view is on this subject, much like we did with regard to unwilling, unable doctrine in drone warfare.
More questions? Front row. I think it's,
Sorry.
Oh, I'm sorry. I didn't see you there.
It's okay. Elise Lockwood. I edit a geopolitical risk analysis publication. I'm curious to hear your views. So we talked about the impact of sovereignty in the cyber world or not. What about the other way around? So how is the cyber world going to affect sovereignty in the future? And I'm thinking specifically of projects like the Good Country. I don't know if you've heard of this. It's based in the UK. It's the idea that they're going to create a virtual nation of people united by values rather than territory. Or BitNation, which already offers e-contracts and state-like services through the blockchain technology. So basically, are we going to see a shift in the concept of sovereignty?
Thank you, ma'am.
Wow.
Great question.
Well, you can go first.
It's too airy-fairy for me. So, you know, maybe. I think it's much more likely if we look just simply at the history of international law, we seldom see dramatic shifts in international law. So I'm not, when I think of sovereignty among whatever, most of what you said, it's like, I don't think so. That's a long way, and I'm sure some academics getting published and getting tenure at the point for pitching this, but I don't think so. But I do believe that cyber activities will affect international law and could do so in a dramatic fashion. And we saw one of those seismic shifts with 9/11, because the law of self-defense until 9/11, with the exception of the scholar Yoram Dinstein, the international community viewed the the right of self-defense as applicable only to attacks conducted by states. By September 12th, at least the Security Council, and soon the rest of the world, took the view that self-defense is applicable to attacks by non-state actors. So the same sort of thing could happen in cyberspace. There could be a cyber incident or that dramatically affects the way we apply international law in cyberspace, that would cause everyone to literally overnight come to a different conclusion. The lawyers have a term for this. It's called instant custom. But notions of sovereignty beyond that, I think it's just not what I do as a black letter lawyer.
I would have given a very similar answer. Normative progress is a very, very slow prospect, and the emergence of international law is a very long-term prospect as well. And so to see virtual states emerge that enjoy sovereignty in the classic sense is something that is not going to happen overnight for sure. But I think cyberspace does affect sovereignty in matters that are perhaps more tangible and more easy to get your head around. And we played with some of those scenarios when we wrote the Talon manual. I think sovereignty will be increasingly less about territory as states become dependent on cyberspace and cyber capabilities. One of the examples that we played with was, it comes from Estonia. Estonia is backing up its critical data, certain databases in Luxembourg. And we discussed this scenario where we've got a malicious state targeting that data that is stored in Luxembourg. Luxembourg has gotten very little sovereign interest in Estonia's data that is stored in Luxembourg's sovereign territory. So the country that would actually have an interest in saying that its sovereignty was breached when that data is targeted, when those databases, for instance, are taken down, it would be Estonia, not Luxembourg. So we asked ourselves the question, well, would Estonia here be in a position to make a plausible claim that its sovereignty was violated when a foreign country took down those databases? And actually here we answered this question differently. Some of us said yes, others said no. So I think in the easier cases, actually we are seeing cyber affect our understanding of sovereignty.
And one of the, obviously we've talked about this at other panels, but just the idea of talking about blockchain, that sort of thing, the law does move slower, as we know, than the technical side, the business side, and that sort of thing, sort of a theme that we've had at some other events, at some other panels. More questions. We've got about 15 more minutes with Mike and Lise in the back. Sir.
Hi, I'm Mike Donahue. I work down at U.S. Special Operations Command.
Mike.
Question, yesterday, Vice Commander CyberCom talked about persistence engagement. So I wanted to get the panel's opinion of if the U.S. takes this type of strategy, where it's a more proactive, active defense outside the traditional boundaries of what we call blue space, what's the international view on that? Would some states perceive this as sort of a relaxation of sort of self-defense rules and use it as an excuse to expand offensive cyber operations outside their own territorial countries? I want to get your opinion on that.
What do you think?
So I've actually been thinking about this. I think it depends on what the United States is going to do. So I think it's a mistake to focus on the concept of defending forward or persistent engagement. I think the better focus is on what is it you intend to do in other states' territory. It would appear to be very clear that if it's merely espionage, then that's not unlawful. That question is, as I said earlier, has been asked and answered. Going beyond there, I would ask, does your response or does your activity fit within some kind of legal framework? So when you're operating outside your territory, there are basically 4 ways you can do that legally. The first is you engage in an operation known as retorsion. These are low-level operations. These are operations that you can engage in without violating the sovereignty of another state or having it amount to intervention, and the example again would be espionage. Above that level is something called a countermeasure. Now, a countermeasure isn't what you think of or what I think of when I was in the Air Force. A countermeasure in international law is an activity that would be unlawful, but for the fact that the reason you're engaging in that unlawful activity is to get the other side, the target state, to knock off its own unlawful activity. So state A violates the sovereignty of state B by interfering in elections. State B conducts countermeasures against, for example, the banking system or government functions in the first state. This would be perfectly lawful. At the next level up is something called the rule of necessity or the plea of necessity. And the plea of necessity says that if the essential interests of a state are being placed in grave and imminent danger, then you may engage in very robust cyber activities or any activities at all in order to defeat that grave and imminent danger to an essential interest. And I would say national security is clearly an essential interest. The economic well-being of the nation is clearly an essential interest. And you may engage in this activity even if you're violating the rights, like sovereignty, of other states that are completely uninvolved with the incident. Why? Because you're in extremis. And then finally, at the highest level is the law of self-defense. And the law of self-defense is very simple. It says that if your state is the victim of an armed attack, either ongoing or imminent, then you may use force, including cyber force, to defend yourself against that armed attack. I will tell you there's uncertainty as to what is an armed attack in cyberspace. But my point is that instead of saying, hey, we're operating over there, which I happen to believe, by the way, is a really good idea, instead of focusing on we're operating over there, I think we should be focusing on what are we doing and what's the model for engaging in extraterritorial cyber operations. I think we'd be a lot further ahead. But I applaud the general premise. It's just make sure that when you're talking about this, make sure that you're talking to your lawyers and you can place your proposed operations in an international legal framework. I will tell you that, again, I had a discussion just before we came in here. I will tell you, in most cases, what a state would want to do extraterritorially, in many cases, it can be justified by international law. You don't have to dispense with international law in order to find legal justification. In most cases, a country that, like the United States, is going to conduct operations for which a reasonable legal argument can be made. And if we can't make a reasonable legal argument, I'm sorry, we ought not be doing it because we're threatening international peace and security. There are exceptions, of course. You know, I'm not completely naive. There are exceptions where a state needs to act in an unlawful manner. This is called a legitimate but unlawful operation. And the example I always use is a non-cyber example. It's Kosovo. Clearly a violation of international law by all of the 19 NATO states that were involved at the time. Nevertheless, it was exactly the right thing to do. And eventually, law has kind of caught up to humanitarian intervention. So once in a while, we need to do things that do not fall within the framework. I get that.
I'm sure the DoD will work hard to ensure that its operations into foreign territory are in compliance with international law. You are a country committed to the rule of international law, so that's probably not problematic. However, law here does not exist in isolation, and policy considerations will come into play as well. And I think that is the difficult area when you're talking about those types of operations, especially occurring in peacetime, because the target states, whatever states they may be, if they find out about those covert cyber operations taking place on cyber infrastructure in their territories, they're not going to be happy about them. That's for sure, especially beyond espionage. Espionage is something that they'll probably accept because we can presume that they themselves engaged in cyber espionage as well. But beyond cyber espionage, states, even though the acting state might claim that the action was in compliance with international law, from a policy perspective, the target states are unlikely to tolerate them.
Excellent. Gary Brown, I think, is next.
Yes, I am. Hi guys. Just to follow up a little bit on the question, both of you did a nice job of answering, getting at part of the answer that we have. But I think when most of us are thinking about persistent engagement or defending forward, we're talking about things that are in that kind of gray area of cyber operations anyway. So it might be something like uninstalling malware, which you know it's not destructive, doesn't disrupt the legitimate purpose of the system, for example, or even maybe even more difficult to categorize in the traditional categorization is pre-implanting accesses or malware that we haven't yet activated, as you know we've talked about a lot before. Where do you think those fit into this, to the structure that you laid out, Mike and Lise, as far as characterizing them as countermeasures or retorsion or whatever? Where do they fit?
For me, uninstalling malware kind of gets into the law enforcement domain, even though that operation may be carried out by a cyber command or by an entity that is not formally law enforcement. This kind of sounds like law enforcement. And international law actually has quite a clear rule about exercising law enforcement functions abroad, and international law says that you're not allowed to do so. And there's even strictly within the law enforcement domain, there is a state practice to this effect. It comes from the Netherlands, and it had to do with the Bredelab botnet takedown some years ago. And there was discussion going on in the Netherlands whether, as part of the botnet takedown process, the Dutch law enforcement authorities should also disinfect the bots so as to make it harder for those compromised computers to be assembled into a new botnet. And that was a very controversial issue because the Dutch authorities knew that it would be politically worrisome to go ahead and start disinfecting computers that are located outside Dutch borders. So even though it might not necessarily be unlawful, especially if the operation is not carried out by a law enforcement agency, I think, again, from a policy perspective, that would be problematic. Pre-positioning malware, that really is, I mean, you are getting at the borderline case. Again, the law does not prohibit it, especially if it's not malware that is set to go off at a particular point in time in the future. But yeah, I know that policy people are struggling with the pre-positioning of malwares, which means that if they're struggling, they're not entirely happy about that either.
Yeah, I think, so Gary, you were part of the Tallinn Manual team for the full 7 years, and I think you know the answer to your own question. First of all, I agree absolutely with Lise with respect to exercising law enforcement abroad. When I mentioned the rules of sovereignty, it was not just about territoriality, it's about interference with inherently governmental functions, law enforcement being the classic example. But let's assume you were wanting to uninstall the malware for reasons other than law enforcement, for national security reasons or pre-positioning. In my view, this brings up the debate we ought to be having. The debate should not be about, is there sovereignty? I mean, for most international lawyers, this is a curious debate at best. The debate ought to be about when is it that you violate sovereignty, and we ought to be looking at issues exactly like this. So I don't have an answer to your question. I'm not so sure that prepositioning malware is necessarily lawful, but I don't know the answer to the question because this is not the discussion we're having, because we've been distracted by this other debate over whether there is a rule of sovereignty. So I like your question. I don't have an answer. I wish states would start discussing these sorts of things, discussing where the thresholds are for violation of sovereignty.
And there's a botnet takedown panel after lunch for your viewing pleasure.
I hope they get it right.
Hopefully they'll get it right. Any last, we have the microphone here, please, sir.
Lieutenant Colonel Toes from UK. I'm not going to speak on behalf of my Attorney General.
Where are you?
Right,
okay.
Third row.
If we're wrestling really with the territoriality within the concept of sovereignty, not whether whether sovereignty exists or not, clearly it does within international law. But is there any sense or potential that there might be a kind of supranational nation-state property rights that might exist? Because property rights as a concept don't have territoriality that come with them. It's more about the relation of the individual organisation to that thing, wherever that thing might exist. So in Lisa's example, where the data would rest in Luxembourg, it would still be belonging to the Estonian government.
My gut feeling is that probably that is the direction in which states will be taking the law. I'm not entirely sure that they will frame it in the context of international property law. I think they will still continue, at least to an extent, to operate with the more common notions that attach to international peace and security affairs. But yes, I think states will be looking at the effects that a particular cyber operation causes to that state and focus less on where the infrastructure or where the data is located, as a result of which those effects are brought about to the state.
Yeah, and additionally, I think it's a really interesting point, and I tend to agree. And by the way, since you're going to be reporting back to someone in the UK, and I'm a professor at a British university, I would want to say that the Attorney General's statement, I agreed with the vast majority. You only got one thing wrong. As a professor, that's a pretty good grade, okay? But I think we also must remember that we have domestic criminal law, and in the case that you posit and that Lee set forward, you could resort to domestic criminal law because jurisdiction would attach because the victim is, in this case, the Estonian government. So you could also look to domestic law, but like Lee's, I agree the law will be moving in the direction you suggest.
We'll go last question, if we could, publicly, and then I think Lee's has an event to get to also, but Mike and I will hang out after. For
what hangs out with you means.
Yes, mostly Mike. Sir.
Thank you. Kakinho, FireEye, Mike and Liz. Do you think over time we will be recalibrating our notion of what constitutes harm? I ask that because, cyber effect has both violent and non-violent consequences, but the way we look at harm, especially like the use of force, we use languages like death and injury to people and destruction to property. But, given the fact that I just mentioned that cyber has got both violent and non-violent consequences, the language in which we are using today, is that still appropriate? I mean, do we need to change that over time? Thank you.
Another great question.
Well, so far I think we have managed to interpret existing international law using the terms that the law employs today without too much trouble. So when the types of consequences, I assume that you referred to non-violent consequences. So we have kind of incorporated those under the notion of damage, but we have, as lawyers, then interpreted damage to not include just physical damage, but also so-called functional damage. And so I think right now, at least, we haven't had too much difficulty operating with the notions that the law has as it stands today. But again, I mean, the law will need to evolve. It's difficult to foresee where the technology will develop, but ultimately, probably the answer to your question is again yes.
Yeah, so from me, it's a resounding yes, because there are lots of questions. Remember what the task of the Tallinn Manual was. It was to determine what the law is today, not what the law should be or what the law would be in the future. And today we're trapped in these concepts of physical damage and injury, which pervade both the law of peacetime and the law of armed conflict. And I just don't think that works well. If I give you an example from the law of armed conflict, we were trying to determine what an attack is under international law during an armed conflict. Why do we need to determine that? We needed to determine that because there's a rule that says you may not attack civilian objects. And so the question is if I'm conducting a cyber operation against that cyber infrastructure, when am I attacking the object such that it now violates international law because the object is civilian in nature? And so, frankly, we all agreed instantly that if you were damaging the object, physically damaging the object, then that fell within, and I could go on for an hour on why we came to that conclusion, but that's pretty clear. But then we had the debate over, yeah, but what if you conduct a cyber operation against the object and it just doesn't work anymore? I mean, you know, it's as I like to say, because it's good illustration, if you hit this MacBook with a hammer or you hit it with a cyber attack that causes it to cease to function, the consequences are exactly the same to me. Can't use it. So we made up, I'll be honest with you, we made up the premise of loss of functionality, which has now moved into the law regarding the prohibition on the use of force and to the law of armed conflict. We made that up because it made sense. And I think we'll be moving in that direction. And this is in both the law regarding the use of force, what is an armed attack to which we can respond with our own use of force, what is a use of force such that if it's conducted against a state, it's a violation of international law, and certainly in the law of armed conflict, because if we apply prevailing notions of harm in the law of armed conflict, we leave our civilian populations horribly, horribly unprotected. And I don't think that's consistent with the underlying object and purpose of that body of law. And I've got an article coming out in the Review of the Red Cross very soon that argues that as a matter of policy, we should start moving in the direction of greater protection of civilian infrastructure and civilians with respect to cyber operations. So it's a wonderful question to end on, because it makes the point that it's sort of a point that, from the question in the back, it makes the point that we need to watch this space, because one of the characteristics of international law is that it is constantly evolving to meet the context in which it is applied. Because if it doesn't accommodate the context in which it's applied, then states will begin to ignore it. So it must be an evolving body of law.
I'm reminded of as we end, the Shakespeare quote, "Save the bold moves for the brilliant players." I think it was Shakespeare. It might have been Billions that I saw it on, but definitely someone said it. And these are the brilliant players in this arena, as you can tell, and they have done a great job laying out some of the bold moves that need to occur in the area of cybersecurity, the law, competition, conflict phase, that sort of thing. I would like to thank the audience for some great questions, really good session, and particularly if you would join me in thanking our panelists for being here today. Thank you, Mike.